Good morning and welcome everybody to Fact Friday. You'll see that I'm joined by Mary Rimmer, who is a solicitor partner and also a Dementia Friends champion. Mary, good morning.
Morning, Michael.
So today we're looking at personal chattels, what they are and how they can be left when someone dies, and also considering the specific gifts of personal belongings. When someone dies, their assets form part of their estate, and this includes all their personal chattels, or otherwise known as personal possessions. These are now defined as tangible, movable property, but not money or securities for money, property used by the deceased at their death solely or mainly for the business purpose, and the property held by the deceased, again at their death solely as an investment. Quite simply and in brief, personal possessions are someone's personal belongings, such as jewellery, painting, and household contents. Previously, personal chattels were defined by law made in 1925, but this was only modernised in 2014. For wills predated the 1st of October 2014, the old definition of chattels will apply, and of course we'd recommend that people should consider whether they want to update their will to allow for the new definition. A specific gift or specific legacy is one where a specific item or class of items, such as jewellery, antiques, shares, or property, is left to a specific person or a group of people. Mary, we have 3 questions today that we need to answer. The first one is, how can someone leave their personal belongings to others in their will?
So if an individual has a will, under the terms of the will, they can specifically gift their personal possessions. It's also common to include a chattels clause in a will, which gives flexibility for items to be distributed in accordance with a letter with the will, or distributed at the executors and trustees' discretion. So the will normally specifies that all personal possessions not specifically gifted would form part of residue of the estate and would then pass to those beneficiaries. So it's important to bear in mind that any gifts in the will would be legally binding and any in a side letter wouldn't be, but it's based on trust that the executor would make those gifts if they're able to do so.
Excellent, thank you. The second question, Mary, a client of mine has a very valuable stamp collection. Should they refer to this in their will, or are they just covered by being a personal chattel?
So the definition of personal chattels, and in particular the exceptions to what's included in the definition, is important because it determines which assets pass to which beneficiaries after someone's died. So an important detail to bear in mind following the change to the definition of personal chattels that you've mentioned is that movable property held solely as an investment is now specifically excluded from the definition. And so if this is to pass with other personal chattels, it has to be specifically added in. So a typical example of that is a valuable stamp or wine collection, which is held exclusively as an investment and not for personal enjoyment. That would not fall within the definition of a personal chattel, and it would be far better to specifically refer to that, which would avoid any uncertainty as to who the client wanted to receive it.
Excellent, thank you. And the last question, Mary, is what happens if I no longer own the item that I have specifically gifted in my will?
Okay, so quite simply, that gift would fail. The technical word for that is redemption. So redemption applies where the subject matter of the gift no longer exists at the date of the testator's death, the person who's made the will. The intended beneficiary of a gift, which fails by redemption, would have no automatic right to any cash equivalent where the subject matter has been sold, for example, or the proceeds of an insurance claim if the asset has been destroyed, unless there was a specific express provision by the person who's made the will. So you'd need to actually make that clear in the will when it's being drafted and include a substitute.
Excellent, thank you, Mary. Great advice as always. Next week, we'll be looking at will structures and in particular, the basic will. Hope you can all make it. See you soon. Take care.